Give a couple of more minutes to bring some people in who are waiting in the waiting room. So if you bear with us for about 30 more seconds. You might hear the bell every so often during this call. Bear with us, we'll bring people in as they join. But we're gonna start now. Thank you everyone for joining. Welcome. My name is Sarah Vanier. I'm the CEO and co-founder of Husmus, and we provide real-time tenant profiling and personalized insurance options such as guarantor and pet damage insurance that support housing provision and access.
And hi everyone, I'm Aidan. I'm a senior policy officer at Crisis. We're a national charity for people experiencing homelessness, and we've been working for nearly 60 years now to end homelessness for good. And we do this in a couple of ways. So we support people directly through our Skylight services. There are 9 up and down the UK. And we also advocate for legislative reform and partner with mission-aligned businesses like Husmus that can reduce barriers to accessing housing. And part of the background for this call is that Crisis's venture studio has invested in Husmus because we like the way that they support all qualified tenants to access the private rented sector, including those people with non-PAYE income or poor credit. So looking forward to it. Thank you.
Before we dive in today, a little bit of housekeeping. For those of you who are not familiar with Google Meet, we're going to take questions today, and the way that you ask your question is if you look at the bottom right-hand side of your screen, you will see a 9-box grid, 3 by 3. Click on that and type in your question, and we will be looking at those periodically through the call. We definitely have time for a Q&A section at the end, so it might be that we reach a button, but we will try to reach everybody. So hopefully, if you're on this call, you're here to hear about the renters' rights reform. And right now, 12 million people are renting homes from private landlords, with many feeling that perhaps the balance of power is too one-sided. The Renters' Rights Act is a new legislation that introduces major reforms designed to rebalance the relationship between landlords and tenants. So, what are the key things that are changing? First thing to note is that this is happening in a couple of phases, with the first phase taking effect on May the 1st. A few things changing. First, landlords would need a legal and valid reason to evict tenants. It will also be illegal for them to put blanket bans on people such as those receiving benefits or families with children. Bidding wars will now be something they cannot do. Landlords must stick to their advertised rent price. Advance rent is now capped at 1 month. Every tenancy now becomes periodic from May the 1st, meaning it's rolling month to month, and people are no longer tied into fixed terms. Landlords can only raise rent annually and must give 2 months' notice when they do so. And tenants also have the right to ask for a pet, which landlords can only refuse with good reason.
Yeah, and that's just phase 1. So the end to no fault evictions is an absolutely massive step forward, as it's the leading trigger for homelessness from the private rented sector at the moment. It's something that Crisis has campaigned for many years, and this is a real landmark moment. But I suppose we do need to acknowledge that the Act isn't a solve-all. Certainly, it doesn't tackle rent affordability, which is really the key driver of homelessness from renters. So what it does do, though, is it gives us more tools to support people at risk of homelessness, and gives people more time to access services, and removes at least some of the barriers to private renting. So we'll go through all of the points that Sarah's listed out there, but we'll start at the beginning and talk through pre-tenancy changes. So with lots of tenants competing for each advertised property, it's not a surprise that can be a source of a lot of anxiety, and there can also be a good degree of unfairness at the start of the home search stage, and certainly discrimination has been a consistent issue that we've seen for our members and many tenants have experienced. So we're really pleased to see that from the 1st of May, there'll be a blanket ban on people receiving benefits and families with children and others having any kind of discrimination against them in that process. That means that landlords and agents can no longer do things like advertise properties with phrases such as no DSS or no housing benefits, no children or professionals only.
It's important to say that although this rule has been in place for a few years now, the difference is now that the government is putting real legislation and action behind it. It seems to be reiterating their previously stated rules of non-discrimination. So let's move on now to the second change that you would see in the house search process, and that's a ban on bidding practices. Because of the high competition that Aidan's kind of highlighted, some agents and landlords kind of fell into the habit of asking tenants who are looking at a home that's really popular for things like, oh, well, what's the highest price that you can offer? You know, this is a very competitive home. Is this the highest that you could go? And those kind of practices are now illegal. Landlords and agents must list a specific price when they advertise the home, and they can't encourage, ask for, or accept offers above that price. This is, of course, going to have a material effect on helping tenants to stay on budget and avoiding last-minute surprises, because we have anecdotally heard that, you know, homes could go for up to 10% or sometimes even 20% more than what was originally advertised. Deposits are staying capped at the 5 weeks that they are. It's just advanced rent payments is now also being capped.
Currently, we also know that in addition to that, many landlords request multiple months of rent in advance, and that can be a major financial barrier. We've certainly seen cases of landlords asking for up to 12 months in advance, and that can be particularly for international students or people without much UK credit history. But from the 1st of May, landlords can only request a maximum of 1 month's rent advance, and that's it, which is really positive. Moving on.
I would definitely agree that that would be a huge money saver for a lot of people, because coming up with 12 months of rent can be extremely challenging for the average person. But if people are still looking to reduce their upfront rent, upfront costs when they're moving homes, they should consider things like deposit-free schemes or guarantor product programs. Husmus definitely offers both, starting from about £9 per month. These tenant shield products will give landlords rent and damage protections without leaving tenants in debt. Are there any other cost-saving solutions that you can suggest, Aidan?
Yeah, definitely. So it does depend on your income and your savings, but you may be able to get support through Universal Credit, and there are fantastic websites like Turn to Us who can help check your benefits eligibility. Or depending on your circumstances, it may be that you can get some support from your local council. It's possible for them to offer sort of one-off payments to support with things like rent deposits through what are currently called discretionary housing payments, and what will be relabeled creatively to housing payments come April. So do reach out to your council for support on that. I'd acknowledge, though, that it can work differently in each area. So the council is the best source for more information on that, but you can also reach out to organisations like Citizens Advice, who can, again, give you some information and support you in applying and accessing funds that may be available to you locally.
Great, thanks for highlighting this. We do have to emphasise that with the changes coming in, many landlords do feel like they've lost some of the safety nets that helped them manage their risk in the past.
Yeah, exactly. And I think that's why we're anticipating that more landlords will be doing things like requesting guarantors more frequently, which is something they tend to do at the moment only for tenants where they perceive there being a higher risk.
Definitely true. It's something we're seeing at Husmus, and it's actually changed a little bit of the practices and their behaviours with assessing tenants, what we've seen is landlords taking advantage of the kind of like the Husmus platform to reference several tenants at once so that they could pick which comes back as the most solid. So my advice for people who think that they might face barriers in the future, for whatever reason, whether it's because they're on benefits, got children, self-employed, or have had past credit issues, is to get ahead of it. Use services that allow you to present your rental history to prospective landlords. Husmus have tenant profiling available, which actually look at what really matters to landlords. So your past rental behavior, your income stability, and your track record. There are other kind of tenant passport services available that you can look at. The idea there is that you're able to walk into a viewing and say, hey, look, I'm really interested in this home, and here is proof that I'm a reliable tenant. Certainly, this act is not going to force landlords to take on tenants that they're genuinely concerned about. But what it is hopefully going to do is going to stop people from making assumptions that are based on stereotypes. Aidan, do you have any thoughts or suggestions for people who might be searching for a home and still running into things like bidding wars or demands for extra rent up front?
Yeah, so most importantly is to challenge them on it, give them an opportunity to comply. But if they still fail to comply, then this is something to report to your local council. And I say that I know that it's not always easy or feasible to report, especially if you're stressed and looking at lots of properties in quite a difficult search. But if you are able to, then I think bit by bit we can start to change the way that the system works for the betterment of for everyone, landlords and tenants included. So the Act does give local councils now more enhanced enforcement powers, and specifically the ability to investigate and fine landlords and agents who break the rules. So the key message, I suppose, is these protections only work if you know about them, if you know your rights, and you're willing to assert them. And while we do hope that landlords and agents will comply, we know that there will be some who do not. And so feeling confident that you understand your rights and that you know how to effectively document everything and push back where possible is going to be key.
Okay, now let's move on from the search process to life after you've moved in. One of the big changes that has got a lot of attention is the pet policy. What that means is from May the 1st, tenants now have a legal right to request a pet, and landlords must consider your request fairly. This request, you have to do it in writing, so tell the landlord about your pet, give a little bit of a description. I'm sure photos of them being very nice will certainly help. And the landlords then have 28 days to respond, and they can only say no if they have a reasonable excuse to do so, not just generally because they are worried about damage a pet might do. So what is considered reasonable? Examples of this would be like if your house is genuinely too small and you're requesting a very large animal. If you perhaps live in a block of flats with a leasehold where the landowner strictly forbids people from having animals. If you're requesting something like a dangerous or prohibited breed, or if the property generally has specific features that could be damaged by a pet. For example, if you're living in a heritage building, for example, that might be a legal reason, but they just certainly can't refuse because they don't like pets or because they're worried about general levels of damage. My advice would also be to get pet damage insurance. You can tell the landlord that, you know, it shows them that you're responsible and that you are actually taking action to protect their property as well. So consider those if you've got a pet or are thinking about a pet. Now, let's look at one of my personal favorites, which is flexible tenancies.
Yeah, so the Act will make all tenancies periodic, meaning they'll roll month to month with no fixed end date. So from the 1st of May, all existing tenancies are going to convert automatically to rolling ones. There's no need for any new paperwork. It'll be done automatically. And from that point onwards as well, no new tenancies could be offered as fixed term at all. And at Crisis, we're really welcoming this change because we know that the end of a fixed term contract can be a bit of a cliff edge. We often support people who struggle to find a new home in time at the end of their fixed term tenancy. So this is a real win from our perspective.
Yeah, and for me personally, I think it's really about life flexibility. You know, if you've got a new job, if you want to move in with your partner, or indeed move out after moving in with your partner, or you're not getting along with housemates, for example, you're not trapped. And the reason I really like it is it gives you a little bit more control over your living conditions. Say you've moved into a home that's not up to a good standard. It looks good on the viewings. But you get there and there's a whole bunch of things wrong with it. You can actually now just leave. You're not tied in for that fixed term, which I think is wonderful. So you give your 2 months notice, no break clause penalties, no negotiating with the landlord. It makes it really in the landlord's interest to keep you comfortable in your home so that you choose to stay in that home. But when you do give your notice, just make sure that it's in writing and properly dated. We have had actually a few advanced questions sent in about the flexible tenancies. The most common one was, can tenants who are currently on a fixed term contract, whenever that may end, hand in 2 months notice from May the 1st?
Yes, they can, but it needs to be in line with the day that their rent is paid. So, for example, if you pay rent every month on the 13th of every month, then you'll be handing in notice from that date onwards. That makes sense.
Of course. And I'm sure if you have the ability to, giving longer notices would be appreciated too. I hope that answers the question. Okay. Let's move on to one of another hot topic, which is rent increases.
Yeah, so we know the rent increases is something that causes a lot of anxiety, and again can lead to homelessness if somebody is not able to access support. So under the old system, a landlord could increase the rent as often as the tenancy allowed, and sometimes this was as frequently as every 6 months, and there wasn't a great deal that tenants could do about it. But from the 1st of May, the rents can only be increased once per year, and that has to be done with a valid Section 13 notice, and your landlord has to give you 2 months of notice in writing, and the increase has to be reflective of market rates in your area. Okay.
And what does market rate mean? That is effectively a term which speaks to looking at comparable homes in your area that for what they are renting right now. So what the comparable means is that it's similar in terms of the number of bedrooms, the approximate size, its condition, and the amenities it offers. So does it have a garden? Do they have individual parking or a garage or something like that? Has it been recently renovated? And then you have to also be very specific in terms of the location. So does it have similar transport links? If you live within, for example, 2 minutes to the train station, you have to then compare your home to other homes with similar distance to a train station, or something like, say, half an hour away. So looking at kind of like a concrete example, say you're living in a 2-bedroom flat in Manchester that's a 5-minute walk from the train station. Your landlord tries to increase your rent, say from 1,000 to 1,200. What you would do is to check listing sites, the common ones, Zoopla, Rightmove, or what other homes within the vicinity of yours with similar facilities rent for. And if that's within range of the 1,200 that's proposed, then that would be classed as a fair market rate increase. But if in your specific case it's not a fair increase, there will now be an official process for you to challenge what's being proposed.
Yeah, so once you're confident in your evidence and you've got it neatly compiled, you can speak to your landlord and or your letting agent, depending on who you usually deal with, and present the evidence and see if you can negotiate a fairer agreement. But if you're not able to agree on this, then there is the option to apply to a first tier tribunal to challenge it. So the tribunal system is designed to be fairly accessible. It's basically an online form. You don't need a solicitor or a lawyer. You just submit your application online with your evidence, and the tribunal reviews it, and their decision will be binding on your landlord.
Am I correct that something like this already exists?
Yeah, it does. But the main difference is the Act will ensure that the process is improved insofar as there are fewer risks for tenants. So now well, as of 1st of May, the tribunal system cannot set a rent higher than the amount originally proposed by the landlord, which was a quirk of the old system. So this is an improvement, but I think one important thing to note on the timing: you do need to apply to the tribunal before the rent increase takes effect, because you don't want it to wait until after you've started paying the higher rent to try to challenge it.
That's a fair point to raise. Do you have any advice for someone who's concerned maybe about challenging the rent increase and worried that maybe it might lead to their eviction?
I mean, absolutely, it is a concern, but under the law, protections are quite clear. So if you exercise your legal right to challenge the rent increase through a tribunal, the law does specify that a landlord is not allowed to evict you in retaliation. I actually think that's quite a nice point to jump off to speak about the new eviction process more generally. New slide, thank you. So we mentioned it up top that probably the biggest change in the Renters' Rights Act is the end to Section 21 no fault evictions. Major connection to homelessness and a big source of anxiety for tenants more generally, and Crisis has been campaigning for many years to see the end to Section 21. So finally, from the May 1st, a landlord has to give a valid reason for eviction and provide evidence at last.
Yeah, I think that's definitely the change that's got the most attention in the news cycle, certainly. But let's break down exactly what grounds there are, because evictions are still possible. We just need to state why a person's being evicted from May the 1st. So first off, things that the tenant has done wrong, so tenant fault grounds as they're known. So this will be things like unpaid rent or repeated delays in payment, causing significant damage to the property, antisocial behavior, or breaking key terms of the tenancy. So that could be things like subletting when you're not allowed to, for example. And each of these have kind of like a different notice period attached to them, which you will have to investigate if that's something that comes up relevant for you. The second category is the grounds that relates to landlord circumstances. So for example, if they are selling up their home, for example, as many landlords are doing at the moment, if they are deciding that they or a close family member wants to move into this home, if the property is being redeveloped. So for example, if it's not been, if it's going through extensive renovations, or if it is being repossessed by the mortgage lender.
And so for most of these grounds, you'll have to receive a 4 months notice period from the landlord for it to be valid. And if they fail to do so, then they are liable for quite significant penalties. And also there are a couple of other protections, like if they say that they're moving back in, or they're trying to move a family member back in, the person actually has to move in, because otherwise the landlords can't re-let the property for another 12 months if they do change their mind, or if they might be be using that grounds unfairly. So there are built-in protections to the system. So again, another positive change through the Act.
Okay. And what should some tenants do if they are served with an eviction notice?
Yeah, first step is always to double check that the eviction notice is valid. So it has to state the specific grounds for eviction, and they have to provide the required notice period. And second, if it is valid, it's important to understand that the notice is just the first step of the process. Your landlord actually can't force you to leave based just on the notice alone. They have to go to court and get a possession order. And you have the right to defend yourself if you do find yourself at this stage. And should mention too that you must attend the court hearing, otherwise the landlord wins by default. But I know all of that process can be really very intimidating. There are quite a few risks associated with it. So my main message is you don't have to navigate that alone. I'd really recommend you reach out to get support if you are facing this. So you can reach out to organisations like Shelter and Suffice on the phone for advice on your situation, or you can get in contact with your local housing law centres if there's one in your area, or potentially even a tenants union if you're a member.
Yeah, I would also add to that and say kind of it's important that if you are facing problems with affordability or anything else that might cause you to breach your tenancy terms, speak to your landlord early. Just, pick up the phone or drop them a message. Don't wait until things really escalate and either debts or damage builds up. If you are a Husmus Shield customer, then we will definitely help with mediating with your landlord if that's something that you would like us to do. And can tenants specifically reach out to Crisis if they need help?
Oh, definitely. And to reiterate what you said, Sarah, it's so important to act early, particularly if you're at risk of homelessness, and reach out for support. So please do get in touch with us. We can signpost you, or we might be able to support you based on your location. But you can also reach out to your local council, who can offer various types of support, and also signpost you to other services. So please speak up.
Yeah, I would say that the end of the no fault evictions does mean more transparency. It just means people just have to be honest about the reason why, and you get protections against maybe some other reasons that they're unjustified. But it doesn't mean that tenants should then absolve themselves of their responsibilities to still do things like pay rent on time, because that's again a contractual obligation, take care of the home, and generally be a good neighbor. So I think let's bring all of this together. We've hit all of the major points now of the phase one changes. 2026 is going to be an interesting year for sure for the rental market. It's evolving from kind of like a casual relationship, I think, between some landlords and tenants to a more professional and service type relationship with clear rules, rights and responsibilities for both sides.
So I suppose for tenants, phase one changes mean that you can't be evicted without a cause, or you can't be legally discriminated against. You have the right to challenge unfair rent increases, to request a pet, and to leave when your circumstances change. And then looking ahead a bit further, there will be further changes coming down the line in phase two. So there'll be a new private landlord ombudsman, which will help mediate and resolve disputes, and also a national landlord database of all private rented homes and of all landlords, which I think we're eagerly awaiting news from government about. I should say very much further in the future, we're expecting quite a few changes to regulations around the quality of private rented homes. So that's the housing conditions and quality. One of those things will be AWEB's law will apply to the private rented sector for the first time, and that will force landlords to fix damp, mould and other hazards in the home within much stricter timeframes. And this is already starting to be phased into social housing. And looking forward all the way to 2035, there'll be a new decent home standard, which will raise standards across the board for all private rented homes.
So remember, look, there are services built specifically for this reality, just like Husmus, where we're helping landlords make fairer decisions with greater accuracy without having to resort to stereotyping. And our guarantor and rent protections helps provide security for both landlords and tenants and reduce the upfront costs.
At Crisis, we're going to continue supporting people at risk of or experiencing homelessness and campaigning to end homelessness for good. I should mention as well, specifically to help tenants understand the Renters' Rights Act, we've been preparing resources on a website in partnership with the Tenancy Deposit Charitable Foundation, Tenancy Deposit Service Charitable Foundation, and that'll be published in April. So do have a look out for that. But I think now it's time to answer some questions. I think we've got how many minutes do we have, Sarah?
We do have a few. Let's start. We've got one here from Andrea who asks, in relation to pets, what about HMOs with shared communal facilities? I'm happy to take that one. So the house being a HMO in itself is not necessarily reason enough for a landlord to say that you're not allowed a pet. However, the landlord will have to take into consideration the other people who live in the home. So for example, you couldn't potentially get a cat if one of your housemates is terribly allergic to one, for example. But if you're living in say a larger, say built to rent, which has multiple communal facilities, it might just be that the landlord might say that, look, certain places are pet free versus others. So it doesn't necessarily halt your enjoyment of your pet. Would you like to add to that, or should we move on to Faye? Faye's asked, with bidding wars banned under the Renters' Rights Bill, is there any risk that landlords will raise asking rents instead? Based on my location, my London flat search last year, every agent urged offers above asking. Can landlords now simply increase the listed rent, and is this expected? This is an interesting one because it kind of forces a little bit more thinking from both the landlord and the agent side. You would have to really consider what you think is fair for your home, because, for example, if it's too high, the rent that they've put in, nobody's going to come and arrange a viewing. So at the same time, they have a balance to strike. I don't think it's going to be a case where people are just blankly going to increase the rent, because you have to remember each flat is also in competition with the ones around it. So if you've increased your rent to an unreasonable amount, you're not going to get any viewings and no one's going to come through anyway. But I do think that people will potentially put in close to what they think is the maximum, but I don't think anyone's going to go too over the top with it, because it will affect the number of people coming to view the home. Any thoughts on that one, Aidan?
Yeah,
I agree with me slightly.
To be candid, I do think there is a bit of a risk that we might see some rent increases as the Renters' Rights Act comes in. The extent to which that'll be the case and how that might play out across different ends of the private renter sector, we're particularly concerned, I suppose, about any impact that might be felt at the lowest end of the market, where people are having to access it with frozen local housing allowance, or that is to say, effectively the housing benefit available through universal credit. We know that end of the market is squeezed already. We're a bit concerned about potential impacts. But that being said, the Act at the very least does put in place, as we outlined, protections against unreasonable increases. I think what we'll have to monitor quite closely and carefully is how effective those measures are in actually dampening unfair rent increases as time goes on. So just to say, great question, and it's something that we're very aware of in our campaigning work.
Definitely, and I think I think it shouldn't be underestimated the power that tenants also have in this, in that if you're looking at a bunch of houses and you see some that are just too high, don't even inquire about the homes, and you have that level of power and hopefully choice. Because if they don't get any viewings and nobody's inquiring about the homes, then they will rethink the price that they've set it as and hopefully bring it down to something that's a little bit more realistic. Okay, we've got a few more questions here. Okay, we've just done Faye, so hopefully that answers your question, Faye. What counts as encouraging bidding war? If an agent just tells me that there are other applicants, is that allowed?
Yeah, the law is quite clear on what counts as encouraging a bidding war. So landlords and agents cannot invite, encourage, or accept anything above the advertised rent. But simply just saying that other people have applied is technically permitted. But it's that moment where they start to suggest that you could offer more, or that maybe a higher offer would be favoured. It's that point where they kind of cross the line.
Yeah, I think you should trust your instincts on that one. It could be an innocent statement. It could be a wink, wink, nudge, nudge. But you don't have to play along with things like that. The price that they've advertised is the price. If you do feel pressured, as kind of like Aidan said earlier, document it, note dates and times and who said what. And hopefully you can put that for somebody in the local council and later on to the landlord ombudsman when they come in place later this year, so that those kind of practices could just be stopped. All right. The rolling contract sounds great for all the reasons you've listed. I do wonder if it causes more insecurity, as the landlord can now give you notice at any point in the year, not just at the end of the contract. I'm happy to start off with this one. So it's not a case of a landlord can literally just give you notice for whatever reason. They could only give notice for something that you've done wrong. So if there's something that if you're not, there are no tenant fault grounds, and then there are no tenant fault grounds, they can't bring anything up on that circumstance, and they can only bring up specific landlord circumstances, being they want to sell or they want to move in themselves, and some of the other things that we listed. So there is security on that, in that there's only specific things that they can give you notice for. And when they do have to give you notice, it's at 4 months is the minimum that they're allowed to give you. But I think, Aidan, I don't know if you want to add to that.
Yeah, no, I do. So probably the best protection that's afforded through the Act in this regard is for the first year of your tenancy, there's a protected period during which you won't be allowed to be evicted. And if you think that the average length of an assured short-hold tenancy at the moment is between a year or maybe 2 years in some cases, effectively that's very similar to the existing protections. I know that some people, and particularly families or people with specific circumstances, may have opted for longer term assured short-hold tenancies to have a bit more stability. And so I will acknowledge there is a bit of a trade-off with some of the changes in this legislation. But I return to some of the points that Sarah raised about the limitations to kind of improvements to properties during those time periods. I think there are, on balance, while it's difficult, I think we're cautiously optimistic that this will be a positive move. And I think the only final thing I'd say on it, and I think Sarah alluded to it in the discussion about the flexibility that this offers. One of the more unfortunate situations that we often support people through is circumstances where they've had to leave a property due to quite severe relationship breakdown or sudden unexpected changes in the circumstances, like job loss or like sudden illness, and the kind of financial liability that comes with being in a fixed term tenancy if for whatever reason it's no longer a safe place for you to be, or because it's no longer financially viable. It's incredibly destructive and quite difficult to get out of. So the idea that you could give only 2 months notice and leave at any point during a tenancy, I think really is something to be celebrated as a change.
I agree. Well said. Last question in the chat. So if somebody hands in a 2-month notice, will they be considered homeless by the council, or could that be considered intentional?
Can you repeat that one more time for me, Sarah?
Of course. So if somebody hands in a 2-month notice, I'm guessing they mean a tenant in this case, will they be considered homeless by the council, or would that be considered intentional?
My assumption would be that that would be considered intentional insofar as they are submitting their own notice to leave the property. So I don't think they would be automatically entitled to any support in that instance. I think it would surely depend on their circumstances.
Agreed. Unless there was an extreme case of the home not being suitable at all, or dangerous to live in, for example, then I would say I would agree with you, Aidan. Okay. I think that's all that we've got time for today. Thank you all so much for joining us. Feel free to reach out to either Husmus or Crisis. We're here to help you navigate this transition. Scan the QR codes to find easy access to our support tools. And thank you all so much for joining us today.
Thanks, everyone.